And where are we on this, John?
Well, I thought we were going to be able to resolve this, but we're unable to. So I guess we're going to have a hearing, Your Honor.
So what's the issue?
Well, I'm not really quite sure. The tenant wants 6 months to move all of the stuff out. That's one issue. And I told him that we can't provide him 6 months. We can give him a little bit more than the 10-day statutory period. And the other thing is that he feels for one reason or another that there was an agreement that if he moved out, which he still hasn't moved out, that he didn't owe any back rent.
This eviction case isn't your average tenant-landlord squabble. This one's packed with delays, emotional pleas, and a warehouse crammed to the ceiling with someone's entire life. The judge, fed up. The tenant, still clinging on, asking for 6 months to move out. And get this, the tenant claims there was a handshake deal to skip back rent if he cleared the place. But here's the twist. He never actually moved out. And when the judge hears that, oh, she snaps. We got missing owners, miscommunication, liquidation auctions, and a courtroom moment so tense. It feels like someone's about to get thrown out today. Watch closely. This judge is not here for excuses. She's handing down reality checks like eviction notices. And you won't believe how it ends.
Did I accurately?
Correct.
Those are.
We had a verbal agreement that if I was to move out, that I would no longer be paying the rent. I told him I couldn't pay the rent and move out. And I thought we had come to a mutual agreement that it would be best for both parties if I just moved everything out.
And it's my client's position that no agreement was made. And even if one was, the client still hasn't moved out and still wants another 6 months to move out, Your Honor.
So you're not disputing that the rent's owed?
Right. Well, I am, because I had an agreement with the landlord to, if I moved out, in lieu of paying the back rent.
Which he hasn't moved out, even if there was an agreement. Your Honor.
But I'm in the process of moving out.
But really, guys, I hear you. You guys can keep repeating it, but I can.
I'm sorry, Your Honor.
From one moment to the next. I get it. So, I mean, there are two parts, so that you understand this, sir. There are two parts of this case. One is the possession.
Did you catch that? The tenant claims they had a verbal agreement. You know, the kind you can't prove in court. He says if he moves out, he wouldn't owe back rent. Problem is, he hasn't moved out. This is courtroom gold because verbal deals without receipts, they don't fly in front of a judge. His whole defense hangs on an understanding that the other side flat out denies. This isn't just bad communication. It's a ticking legal time bomb.
Issue, and then the monetary issue. In terms of the possession issue, I don't see that there's an issue for me to try, because the condition of you staying is, first of all, to pay rent. Even if, I'm not saying that I'd make a finding that there is, even if there is this other agreement that you move and you don't owe the rent, the only bearing that has on the possession issue is you were supposed to move, right? So I can bifurcate the hearing so that we deal with just the possession issue and then set it for a further hearing as to the money claim. But if I do that, then the question is when are you going to move? Because I think they'd be entitled to a judgment for possession. And the reality is that if I do that, finding no tribal issue on the issue of possession, it's going to be 10 days. I can tell you that even using my discretion, I wouldn't give you 6 months to move. So if we just deal with that part of it, when can you be out?
This judge just dissected the case like a surgeon. Two parts, possession and money. And when it comes to possession, the judge sees no gray area. If you're supposed to be out and you're still in, game over. The judge even offers a compromise, settle possession now, and we'll worry about the money later. But the tenant wants 6 months. 6. The courtroom energy shifts hard here. You can feel it The judge is done being patient.
I mean, I said realistically 6 months because there's so much stuff. I understand that that's not agreeable, with them. But I've tried to work with them. I even offered another solution to, conduct a liquidation auction. But I said even that's going to take, probably 2 months realistically, and everything still won't sell. So I did make a promise that I would clear the property out, in lieu of not paying rent, that I would make sure that it was, left empty. And that's why I came up with the 6 months, because I know that's still gonna take time, even after I liquidate, a vast majority of the stuff. It's still gonna take time to remove the junk, and I'm willing to pay for the removal of all the trash that's in there and leave it empty. But I don't think that's agreeable.
Well, they've said it's not agreeable.
The other problem I'm having is
Here comes a drama bomb. This is in a small apartment. The guy's squatting in a 10,000 square foot warehouse. Yeah, that's right. He's arguing that moving out takes months because the place is packed. And sure, it's a logistical nightmare. But in court, sympathy doesn't equal possession rights. He's tossing out ideas like auctions and trash removal. But the judge sees it for what it is, a stall tactic. He's trying to delay the inevitable.
just found out recently, a few minutes ago, that the person I've been dealing with apparently is no longer the owner of the property. So the person that I've been dealing with, the person that I had a verbal agreement with, I guess is no longer, making the calls, and I was not aware of that, which I guess explains why I haven't heard back from the person that I had made this deal with, because I just found that out a few minutes ago.
Well, Your Honor, speaking to that aspect only, the owner's still the owner. The son has been managing the property for the last year or so. So I don't know I think that's what you're referring to, correct?
I guess I just meant I wasn't aware that the person that I was talking to isn't actually running the operation anymore. So when I was told, I won't charge you any rent if you can move everything out, and at the time I talked to him last, I didn't give him a time.
That's, again, the problem with that is, if I assume that's true, you haven't moved.
I'm in the
Which
process.
means if you haven't moved, that means you still owe the rent. Right? Which means they'd be entitled to a judgment and you'd still owe the money.
But the agreement that I had was that I wouldn't be paying anymore if I moved out.
But you haven't moved out.
Correct. I'm in the process of moving out.
Well, according to his own words, Your Honor, that's a 6 months ordeal. So, I mean, I could say I'm moving out of my house by taking a dish at a time.
Well, this isn't a one bedroom apartment. This is a 10,000 square foot warehouse packed to the rafters with.
Now he's shifting blame, saying the person he made the deal with isn't even a property owner anymore. Classic move. Suddenly, it's not just about back rent. It's about who's in charge. But the judge doesn't blink. The owner's son has been managing the property for over a year. Translation, your verbal deal still doesn't cut it. This guy's running out lifelines fast, and the judge is sharpening the legal scissors.
It took several years.
I get back to my same question. For you, how much time are you looking? 6 months is not going to happen.
Okay.
So here, just let me finish this. The statutory period would be 10 days.
Right.
I get the circumstance that you're in, so maybe that's not realistic that it's the 10 days.
Right.
But I can tell you that even if I use the furthest reaches of my discretion to give additional time, it's not going to be near 6 months.
Okay.
And so if you guys can't decide, I'm going to pick a date on the possession issue, and then I set it for trial on the monetary issue. But you guys are going to have to decide. It's going to have to be something realistic, sir. I mean, they're entitled to the possession of their property by even what your agreement was. They're entitled to possession.
I mean, I can guarantee I can't move everything out in 10 days. It's not,
How much, what would be the fastest?
I mean, 4 months, is that agreeable?
No, that still puts us in the same position.
It's, like I said, I've probably moved half of it out within the past, 3 months. It's gonna take, I would say, at least 4 months, realistically.
I mean, no,
We'll let Your Honor make that decision.
that's really don't want me to do that. Nobody gets happy then. But
The judge is crystal clear now. You're not getting 6 months. Not even close. She offers the maximum discretion she's legally allowed, and it's still nowhere near what he's asking. And then comes a cold, hard reality. If you can't decide, I will. That line? That's the gavel dropping without sound. Judges don't make threats. They make orders. And this one's about to do exactly that.
listen to everybody. As to the issue of possession, I'm going to find that there's no tribal issue as to the issue of possession only. I'm going to issue an order of eviction on or after June 30th.
After what, June 30th, Your Honor?
Yes, June 30th.
Thank you very much.
I will also, on the monetary, on the damages and money issues on the case, I'll set a trial on that matter for July 15th, 2025 at 9 a.m.
Thank you. And I will prepare the order on the possession. I'll submit it to the court. I'll submit a copy to you.
Will I be getting a copy? Because that's the other thing. I haven't received any court summons or anything.
Well, we have a proof of service in the file, Your Honor.
What do you mean you haven't received any summons?
The only summons that I received was the one that was taped to the door, and
Oh, that's service.
I was under the impression that I was also supposed to be mailed something as well. The one that was taped to the door had the address in Saline, which is why I wasn't here at noon, because I went to the courthouse in Saline and they said, "Oh, you're at the wrong place." And then I called the number that was on the summons, and the number was for Wayne County Courthouse. So my summons that I received on the door was little.
So what do you want me to do with that? You're here. I've heard your case.
I'm just saying, am I going to receive
Yes,
mailing?
I'll tell you what, here's what we'll do. You'll get a judgment. Prepare a judgment. I'll sign it and I'll give you a copy. Thank you.
Boom, there it is. Eviction order lands like a hammer. Out by June 30th. After all the excuses, delays, and I'm still moving stories, the judge draws a line. And just like that, possession is settled. The rest? A money trial set for July 15th. The tenant tries to argue service issues, claims he didn't even get the right summons. But it's too late. You showed up, you got heard, and now you gotta go. This is what courtroom closure looks like. Firm, final, and unbothered.
Well, and then get it all prepared and then I'll do that.
Thank you, Your Honor.
This judge wasn't playing games. No more delays, no more deals, no more excuses. The tenant wanted 6 months. He got 10 days. This case is a masterclass in courtroom patience and how fast it runs out. If you ever wonder what happens when you overstay your welcome and try to fend it with a handshake deal, this is it. And we're not done yet. The money battle's up next. If you found this case as wild as we did, smash that like button, drop your hot take in the comments, and make sure to subscribe for more brutal courtroom breakdowns, where justice doesn't wait.